But in the meantime, welcome. Hope you're all doing well and have your lunch, whatever that might be. I'm still riding behind my bowl of Wheaties this morning, so I can hang out a little bit. Adam, it occurred to me that we maybe should have done this at 12:30 so people could have time to grab a sandwich and soup and all that kind of stuff. But I've got about 23 right now. So it looks like we'll have a good turnout. I think this is a really timely issue, so thanks for doing this with me.
Absolutely.
So yeah, let's just, again, we want to keep this nice and tight. The idea is to keep this within half an hour so you can kind of go about your lives. So let's kind of, commence with the housekeeping at this point and kind of the background information. So yeah, Leafy seminars. This is our seminar series. We put this on about every other month. This is our 5th session. And we've done a number of different legal issues. We've been focusing on Maine and Massachusetts for this one. I'm sorry that being an in-person seminar series, and it's now kind of morphed into this easier to access and put on, frankly, online webinar series. So please let us know if you have any thoughts about which you want to see in these. And we definitely do want to make sure that we're responsive to the needs of the industry, and really just to people who are trying to learn as much as they can about how they fit into this. And the function of this is really to kind of educate as many people as possible. So this is Cannabis Energy Regulations webinar, sponsored today by Prince Lobel, a law firm based in Massachusetts, which has been tracking this for a long time. And I'm glad to have Adam Ryard join us today from Lobel. We've been a great organization and have a really robust cannabis operation. And today we're also really happy to be collecting donations for the Cannabis Center of Excellence. You may have seen their name pop up in the registration page. And thank you so much, everybody who donated to this great organization, this great cause. They do fantastic work, and full disclosure, I'm on the advisory board of the Cannabis Center of Excellence. And a big shout out to Marion and Randy, the folks there who are really kind of making that a really one-of-a-kind amazing organization. So how this will work, again, we want to keep this nice and tight, emphasizing quality over quantity as much as we can, and kind of and wrap up hopefully promptly around 12:30. So Adam and I will talk for about 10 minutes. Adam will kind of kick things off and give kind of an encapsulation of what energy regulations are at this point, and then kind of I'll summarize that and kind of interact with Adam over the course of the presentation. And then I'll talk about some of the compliance, kind of the information that the state needs, and documentation, and how you can get there, and kind of what are some of those pain points. If you have questions, please put them in the Q&A. We will certainly be, we will respond to them as we can. And if we have to go over 12:30, I know that I'll be around a little bit to answer questions, and you can always reach out to Adam or me directly as well. So without further ado, I want to hand it over to Adam. Adam's a partner at Prince Lobel, and helps to head up their cannabis, real estate communications, and renewable energy departments in their operations. So really well qualified to speak about cannabis and energy, and lucky to have him. So Adam, I will run the slides for you. Do you see your slides here?
I've got them. Thank you.
Great.
Sam, thanks very much. Thanks for allowing us to be part of the Leafy seminar series. We've done a couple of these together, which have been great, both in Massachusetts and in Maine. Also, just want to note that Julie Berry is also a partner in our real estate and environmental and cannabis practice group, and there she is, and she helped with this, as well as the alert that we put out last week in connection with these regulations. As of, I think, as everyone may know on the presentation here, on the webinar that the rules are effectively in effect as of July 1st this year, or 21, 22 days ago. So we think this is timely, as Sam says. And basically what that means is these regulations that have been in the 935 CMR 500 and 501 for a while are need to be addressed. It's something to start focusing on this now that they've passed their July 1 kind of timeline. So with that, what I want to do is basically just go over the regulations, where this all comes from, address the 935 CMR 500 501. I've only in the slides focused on 500, which is the adult use, 501 medical, as we know, effectively identical. But just for clarification purposes, just want to put in 500 for now. If anyone has any questions on the medical side, we can address those either on or offline. Thanks again, Sam. So, as Sam said, I work in our renewable energy and cannabis and real estate and telecommunications practice at Prince Bell in our Boston office. And so I think I check a bunch of the boxes here, but we'll see as the questions come in. So just getting into this, focusing on some of the the important regulations. CMR 500-105 basically is the general operating or operational requirements. 105.1Q and 105.15 effectively say the same thing, which are written operational, or the establishments. All establishments need written operational procedures for energy efficiency. Those procedures and protocols should include and consider basically the following here, which are energy use, reduction opportunities, renewable energy opportunities, reduced electrical demand, and energy efficiency programs. So, for example, energy use reduction opportunities would be energy efficiency equipment. You need to have in your written operational procedures when you're filing your applications or during your operations, procedures that you consider energy efficiency equipment. Similarly, with the renewable energy consideration, that you've considered, if you're a cultivation facility within a building, have you looked at the roof for, potential for the roof-mounted photovoltaic solar or ground-mounted solar, or wind, small scale or large scale? Were there opportunities to be involved in some of the incentives that Massachusetts have, like the SMART program, or other renewable energy opportunities, geothermal, things like that? So you should have in your drafted operational procedures have referenced that you've at least identified or considered that, and the reasons why you are or are not moving forward. Strategies to reduce electric demand. Example of that would be measuring your daily demand, or your weekly or monthly, yearly demand. When you are using more electricity, what's your load look like on a given day? What they call considered load curtailment. Are you able to shut things on and off at certain times? Is there opportunity for storage, electricity storage, where you could save storage at a certain time and then blow it to your system or your HVAC units when it's high demand, when it's a high peak demand time during the day? So those are all the things that the Cannabis Control Commission is really asking that all the establishments are considering. And then final thing is engagement in energy efficiency programs offered through municipal power and light plants. So example of that would be in Massachusetts, they have what they call Mass Save, which provides incentives for energy efficiency measures. So these regulations right here, really, the intent is that the written operations and procedures should show the Cannabis Control Commission that you've considered ways to optimize your energy use. I mean, it's really that simple. Go to the next slide.
Yeah, just a quick thing on that. I often kind of think of this section of the rules as a kind of leading. You know, I mean, this is the state. I think, you know, trying to basically, you know, provide resources and tools to licensees, saying, listen, these are all great ways that you can, you know, save money, save energy, and kind of reduce kind of the impact of, you know, a highly energy intensive operation. And you know, and these are all going to be great things for folks to do. It doesn't require anybody to do them. But it's really, yeah, I think it would behoove, you know, every licensed applicant to look at these seriously. And there are companies that will come and these things for you and do it for free, basically. Because in almost every case, you know, there can be a real, you know, money savings. I mean, money making opportunity. You know, if you kind of pursue some of these. So
yeah, Sam, that's a really good point, and I sometimes get away from it and get so focused on the regs, but practically, operationally, that's the whole idea here. Is that cannabis, the commission is saying, hey, consider these things. Show us that you consider these things, and you know, we think it's going to pay off in the long run from an operational standpoint.
Yeah, and conventional, commercial, industrial do this stuff all the time. So it just makes sense that cannabis companies, you know, at least should know that they exist. So next slide.
Right. So next slide here, this is in addition to what we just talked about in 500 105. This is specific to indoor and outdoor cultivators. So in addition to what we just discussed, indoor and outdoor cultivators also need to do the following. Under 120.11, cultivators are subject to equipment standards. So these are requirements that the Cannabis Control Commission is going to hold the indoor-outdoor cultivators to. The building envelope, and that the building envelope meets all Mass building code regulations. Now, there is an exception here, and that's with respect to greenhouses, and we can go into that in a little more detail on our exception slide. The next standard is lighting, and probably a lot of people know about this, horticultural lighting, power density requirements, right? And the requirements for, you know, 30, not greater than 36 or 36 per square foot for any cultivation canopy over tier 2. Tier 1 and 2 would be restriction of 50 watts per square foot or
yeah.
More.
And just a note on that, if you don't mind me interrupting for a second. On Friday, the commission, as folks may know, put out an FAQ document, which is basically kind of their clarification of the energy rules. And there's one component of that which is really important that people should understand. The commission really limited the definition of canopy for the purpose of defining lighting power density standard. So before there's some open interpretation that you could define the entire grow room, you know, as canopy as the square foot denominator figure. But the CCC on Friday just said no, it's got to be tables, basically. They're racks.
Right.
Is kind of what measure. So no hallways, no aisles. So that's kind of a really big, I think people kind of knew that was always the case, sort of. We're interpreting it as loosely as they can. But that's a big thing that just came out on Friday.
Yeah, it's great. Good point. You know, the Q&A that came out on Friday that addressed that, and that question also answered some of the general questions that people had, I think, with respect to, hey, what tier am I actually, you know, from a cultivation standpoint? So I consider this. So it's pretty helpful. And we have links to that Q&A session, as well as the guidelines that we'll talk about too. and the regulations.
Yep.
So those are not required, or you can exceed those restrictions if the cultivator complies with the horticultural lighting qualified product list. So if their lights are within this or come from this list of certified lighting, then because of the way that those that lighting is powered and their densities, that you can do not have to comply with the restrictions here. That led on the energy and environmental compliance guidelines that the Cannabis Control Commission issued at the beginning of the year. As well as energy envelope, building envelope and lighting, there's also HVAC and dehumidifier system requirements under Mass Building Code. There's also a safety plan that the Cannabis Control Commission is going to look. For example, there you want to see eye safety plans that are on site, and then also these would all need to be wrapped up in a energy compliance letter that would need to be provided to the architectural stage. And Sam will certainly go into a lot more detail on what's required for the energy compliance letter. So also, in addition to what we just talked about on the last slide and these requirements, and Sam, maybe if you can just scroll up a little bit. I'm not sure if everyone can see that whole slide, but cultivator. Yeah, if you could scroll up just a bit without going to the next slide.
I'm not sure if I can.
Okay. That's okay.
To be full view.
In addition to what we just talked about, cultivators should maintain energy efficiency written policies and procedures on an ongoing basis that include renewable energy and water usage. Reduced energy and water usage, and engage in energy conservation and mitigate other environmental impacts. So it's basically what we've been talking about. You need to show the commission that you are enforcing your reduced and trying to reduce energy and water usage and complying with the energy conservation requirements on an ongoing basis. So what does that mean? Well, you're gonna need to provide something in your initial application, a provisional license. You're going to need to some extent provide a energy compliance letter during the architectural stage. So that's post provisional, but prior to final licensure. And then on an ongoing basis during your renewals, you're going to have to provide your reports to this nature. All right, next slide. So this one is just it's identical to cultivation with respect to the energy efficiency and written procedures and policies. It's just in connection with product manufacturing. So they go hand in hand, obviously, cultivation and product manufacturers. You generally are one under the same roof, sometimes not, but this just basically spells out that product manufacturers also have to comply with the ongoing reporting requirements. Next slide, Sam. Thanks.
All right.
To hit it again.
It's coming. There we go.
There we go. All right. So this addresses some of the exceptions that are within the regulations. We referenced a couple of slides ago, 120.11, A, B, C, D, and F. Well, E and G of that regulation provide some exceptions and then some relief from timelines. So 11E basically says if the requirements for 11B, which are the HVAC and dehumidifier standards, are not required for indoor cultivation if the establishment is generating 80% or more of the total annual on-site energy use from on-site clean or renewable generating sources. So what does all that mean? Well, before I get there, it's an 80% rule, but in addition to that, the cultivator must document renewable energy credits or alternative energy credits representing the portion of the site have been purchased and retired on an annual basis. So I kind of read those word for word because it's interesting, but basically what it says is if you want to avoid 11B and 11C, which is the lighting and the HVAC dehumidifier requirements, you can. If you can show that you are providing at least 80% of your load by on-site renewable energy sources. So what's that? Well, that is, look, we kind of talked about earlier, wind, wind turbines, either on smaller wind turbines on the roof or on the ground, solar, photovoltaic, either ground mount or rooftop. They list, the list is all in the guidelines, and it references the Massachusetts regulations with respect to renewable energy and the energy portfolio standards. But they list a number of things like ocean tidal, geothermal, hydro. So there's a number of things that may not be practical, just based on locations of where the facilities are, but it provides a significant list. And then 80% or more, and the rest of it needs to be provided by credits, and that's purchasing of net metering or other forms of incentives, either by the SMART program or the solar renewable energy certificates or credits. So that's a whole another presentation that we could put on at some point. So if anyone has questions on how they get there, we can certainly address those offline.
And just on that point, I'm sorry if I can interrupt a little bit.
Sure.
That 80% on-site renewable energy or clean energy carbon generation is really hard to get. And at first the commission had 100% as the exemption standard, and they moved down to 80. I still think 80 is challenging. And this is also does not include on-site generation from combined heat and power systems that are powered by natural gas. So that's something you see kind of more and more cultivators doing, installing these CHP systems, the cogen systems, but they run on natural gas. It doesn't count as on-site clean energy, clean power generation source. However, you run biogas through it, which is methane from obviously natural sources, meaning not natural gas, but from digested foods. But that's I have not seen that. So this is a tough exemption to get.
Yeah, it's a really good point. I mean, the cultivators are pretty high users of energy, and I don't think I've seen and maybe they're out there, but I haven't seen a situation where a cultivator is able to offset 80% or more of its electricity from, for example, photovoltaic solar on the roof. There just isn't enough space.
No, yeah, I haven't either.
Okay, so
Adam, can I move you along if you don't mind?
Yeah, just said one other thing, and you'll go into this in a little more detail. But just wanted everyone to be aware that if there's a requirement for the energy compliance letter that the Cannabis Control Commission may issue, may allow for a 6-month extension if you're showing that you have installed meters to monitor your energy use and water usage, and that you're reporting on that usage. And so that's from a regulatory standpoint, that's really the meat and potatoes, so to speak, of where the requirements come from. And right now, I think Sam, it's to you to kind of some detail of the end.
Sounds great. Yeah, I'll take us home. So yeah, quick intro for myself. In addition to being the MC for Leafy seminars, I own and operate a consulting shop called Climate Resources Group, and we have a cannabis business service project or initiative called Enlighten Your Grow, which really helps businesses, cannabis businesses, kind of build and operate kind of more productive facilities, reducing their energy inputs and resource inputs, and kind of squeezing as much yield as possible out of their facilities. So yeah, in summary, that's kind of what I kind of this kind of this little Venn diagram. I won't kind of belabor everything that Adam already said, but just you can think about as cultivators having kind of the most requirements, followed by everybody else, and really kind of the main parts cultivators kind of need to deal with. And again, this is part of the new for 2020 is that they now have clarity around how to demonstrate their compliance with the light hardency standard and the HVAC standard and the building envelope. Before the guidance came out in January, there wasn't really any specificity on how they do this. So resulted in some license holders kind of not really taking those steps. But now with the guidance out in January and July 1 as being kind of the go live date for those, folks are really kind of taking this more and more seriously. And in my work, in my consulting work, we're seeing a lot of interest in how can cultivators kind of be meet the law and actually demonstrate through this energy compliance letter. And then also the energy use report, as Adam mentioned, is that folks that renewal output of their term. So yeah, I'll just spend a few moments on the energy compliance piece. And again, your ability to be compliant and to kind of have your application proceed through the process is this is one of the fundamental things. I mean, not fundamental. This is one of the key things that they need to have you do. So submit one of these three things. The energy compliance letter would be the best because that means that you've got the green light. And in that letter, it needs to really contain a number of different things, but they fall into the category lighting and HVAC. There's the submission to the CCC can be hundreds of pages long. It's a lot of diagrams. They need your engineering plans, your stamped plans for lighting, all the spec sheets for HVAC equipment. They need a report from ComCheck, which is it's a free building monitoring tool that folks can use in the trades. So these are all things that the state requires, and they're all kind of kicker, I suppose, is that it needs to be an engineer or a registered architect, and so you need someone who's kind of not part of your team. It doesn't come from your company, but has to be signed and stamped by a third party. So that's kind of the service that we provide. And again, as Adam mentioned, if you can't do that, well, if you want to generate 80% or more on-site load, that's fine. You can get a compliance for that, exemption for that. But if you can't comply, generally because 36-watt rule is kind of the big survey worksheet, which is like I think a 25-page long basically survey. And there's really a lot of detail about your operation that the state is basically asking you to do. You have to really prove that you're doing everything you possibly can to gain compliance. And this also includes needing to install monitors or meters for energy use, for water use, for waste. It looks like it have to be done yet, but I'm sure as we see the lighting standard really kick in, and you feel pain, you may see more of these.
Hey, Sam, just a quick question. I just see a question here, and I know that you're wrapping up, but it's kind of timely in terms of when the question came out, when you were just talking about the requirements for metering.
Will you read the question out loud?
Yeah, so basically the question is, why are regulators not pushing enforcement and reporting? Um, that's the question. The gist of it is operators from not adding meters and neglecting data reporting. 6 months is not going to mean much of if they still have to follow the stringent rules long term.
Mm-hmm.
They see them as financially compromising. Why are the regulators not pushing enforcement and reporting? My knee-jerk reaction there is they are going to now, as of July 1, but I don't know if you have any more insight there.
Yeah, I mean, I think the kind of this general frustration on the part of many, at least in the environmental community, that those rules have not been kind of stringently enforced. Like since 2018, there's been kind of high level language about energy and environmental performance, but there really hasn't been any teeth until now. And actually, this slide is relevant now because this gets to kind of what enforcement looks like. And the question, at the end of the day, there isn't really that much clarity yet. We know that there'll be delay in your application. If you don't check, and we're seeing people really starting to freak out about, like, all right, we need to get this done immediately in order to proceed through the process. You think about how much money and investment is riding on getting set up, getting going on time. This is really an important part. The other enforcement kind of implications, we don't really know yet. I've actually invited the CCC to join us today to provide kind of their thoughts, their input into their enforcement plan. They decline just because they don't do that kind of thing, apparently, in terms of participating. But I do I believe, and I'm almost sure, that they will make kind of their enforcement implications more and more clear as time goes on. But I think it's safe to say that they're taking it seriously. At the very least, you're going to see your application delayed if you don't submit if you're not compliant by submitting your energy compliance letter. Had any thoughts on that?
Yeah, no, that's my thought as well. The trends have been with the mission that they certainly do hand out regulatory fees for all kinds of reasons when establishments are not conforming to the requirements that they said they would. And there's a long list of those, and the fees that we've seen, and sanctions we've seen, penalties we've seen with our in our practice. In our practice, I haven't have not seen any. It doesn't mean that there hasn't been any. I personally haven't seen any. I haven't seen any yet, but I think that they will be there. I think that the fact that the commission provided a timeline, and they have now said that you have to conform to this timeline, and that even before you file your provisional, you need to include that you're thinking about this. That those sanctions will come down at some point. When I'm not sure when that'll happen, but certainly sometime now that they've said July. And what would they be? My sense is it depends on at what point of the stage you're in. If you're provisional and you haven't not provided any additional information in connection with energy efficiency, you get your RFI, your request for more information, before they issue your provisional. They're going to say, where's the report, or where's your study, or your plan for energy efficiency. So you have to create one. If it's in between where you've gotten your provisional, but you haven't provided the energy compliance letter, they're going to say, where is it? If you get your final and you're up and running, you're operational, and you go for your renewal, and they missed it, or they just haven't come in and done their their routine check. They may not give you the renewal license.
Mm-hmm. Yeah, it'll be interesting to see how that all goes down, because I know that CCC is definitely hitting hard on other on some of the other rules in terms of pesticides, and certainly in terms of ownership regulations. So I don't see any reason why they wouldn't have a. We do have a question. I'm aware that it is 12:36, and thank you all for hanging out with us a little bit longer. We still have a really good crowd, which is great.
Sam,
but,
I missed a question here, but I'll grab it now if you don't mind. One of the questions: how many mass cultivators have achieved 80% on-site renewables? Has anyone come close?
I think we answered that. I think the answer is no.
I would say that, and this is definitely not plugging any company, but I do know that, and then not a client, but solar therapy of combining solar renewable energy and cannabis. And so if I would start there, if I was to research this question, that's where I would start. Yeah,
and they also have that cultivation operation. Some solar therapeutics also has a cogen, I believe. And actually, it's a question that Charles has: is are there non-natural gas options for cogeneration that are considered clean? The answer is yes. And it's funny, it actually came up in the FAQ document, which dropped on Friday. I won't read the whole answer, but yes, or biogas, cogen, and assuming you can produce 80% of your power with that, then you're good. I've actually, in my kind of sustainability consulting work, been thinking a lot about how do we create these closed circular economies where you can produce power for a campus using the waste inputs from cultivators and other folks. So there could really be an opportunity there, but no one's doing that quite yet. A couple more questions. Yes, Patrick, there will be. I'll send a link to that, and you can share it widely. And Marianne has a question for you, Adam. She asks, how many, if any, of your clients may use a corporate social responsibility approach in order to reduce energy usage or environmental impact? Any thoughts there?
Yeah, no, it's a really interesting question. The quick answer is we haven't had any, and this is all fairly, even though the regs have been there a long time, the enforcement of the regs and the teeth, like you said, Sam, has not been. And so I haven't seen anything to this going that way, but I think it's a great idea. I mean, if a client already has its corporate social responsibilities mandates as part of its business plan, then absolutely that's where I would start and tweak those responsibilities and requirements accordingly to conform to the regulations.
Mm-hmm. Yeah, and this is something that I think about also in my private practice is how do you, and ideally really to get companies moving on energy efficiency and renewables, on energy demand, all these things that CCC kind of wants us to do. They're doing this in other businesses, not because they have to be compliant, but because they actually see it makes good business sense. They see it makes good sense in terms of their triple bottom line for the company. So I'll be excited for the day when we see more and more of this coming up. I know there are a couple of cultivators in Massachusetts now that have a CSR program, and hopefully have some influence with the organizations. I know Canada, there's an organization that basically it's an industry association, but they are all about kind of the of the industry. And in the U.S., we're seeing some nonprofits, and organizations start to come together around those pieces. So it'll be there. It's coming. So I think that's all the questions we have. I just want to thank everybody for coming and for participating in this with us. So it's really exciting time to be following this. And thank you, Adam, and thank you, Principal Bell, for sponsoring this. As mentioned, we will be sending out a survey at the end of the this event. I would love to have your feedback, and certainly love to get your feedback in terms of what seminars you want to see us do next. Thank you so much for tuning in. And,
thanks very much, Sam. And just, if anyone has any questions, I'd look at the slide now that's out there. And if you need immediate questions, take a picture of that. Give one of us a call if you need any help. Really appreciate it.
That's right. Yeah, no, thanks for that nudge. And yeah, absolutely. So yeah, Principal Bell is a stellar law firm, and for my work, we do energy sustainability consulting for the cannabis industry and others, but really doing a lot of work on the compliance piece. So this is great. Thanks, Adam. I appreciate it. Thanks, everybody. Have a good day.
Thank you.